As to the history of convictions or behavior, there is the most minimum of misdemeanor history in this case. And on top of that, it was this failure to appear in Sullivan County where she was sentenced to do community service and gets raped by the officer who's managing the community service program 18 months before this incident, which, as I will argue later, contributed to the PTSD that she was suffering at the time this happened. And the abuse of Mr. Oliver, who apparently is not going to be standing here today saying anything either.
Your Honor, he is going to give a victim impact statement. He has asked the state to read it, just to let the court know.
He has the right under the statute to give a victim impact statement.
I understand that. He will not be giving the victim impact statement. He'll have them read it. He didn't testify at trial, though some of what he said was used. So
focus on the enhancement and the mitigating factors.
that is one of what we'll also be arguing as mitigation. The state wants to talk about uncharged drug transactions. The court might recall Ms. Howington's interrogation and how many times Riddle told her, "We ain't the drug police. We don't care about drug cases. This ain't about drugs. This is about a 5-year-old child who's dead." Then we introduce it at trial. Now we argue it at sentencing, even though she wasn't charged. So I would suggest that none of that should apply, Judge. Rumors of conduct should not be used for sentencing purposes in a case like this or any other case. But there are constitutional guidelines for a reason in the plea agreement form, which is produced by the court, and in those cubby holes over there it talks about, you understand that if you enter this plea, these charges could be used if you are convicted of something in the future. The idea of vulnerability of the child, that is one of the elements in the child neglect. So
I think they're only urging that as to count one, the reckless homicide.
And I don't know how you use that in what the jury had an opportunity to convict her of, felony first-degree murder. Did not, and found reckless homicide. And so a reckless act is not something that should be considered when we talk about the age of the victim. What they said was, that the state said, no one's going to tell you that she intended to do this.
Well, what the case law says interpreting that particular factor is that there has to be the vulnerability of the victim has to be in some way causally connected. In other words, it was easier for the defendant to commit the crime because of the particular vulnerability of the victim, be it age or some form of infirmity. And
I would suggest that either under a negligence theory or reckless she was convicted of, there's nothing that would suggest this crime was committed in order to take advantage of the young age of the individual. So I don't think that applies, Judge. And again, injuries inflicted upon the victim were particularly great. Again, she was charged with felony first-degree murder, was not convicted of that. And so we're back to the reckless homicide. And
well, death's an element of reckless homicide.
Right. And so
I think the argument is that the injuries as to count 2, the aggravated child neglect count, that the statute requires that they prove serious bodily injury. In this instance, it went beyond that; it was death.
Well, and what we have is a case in which count 1 was homicide, a felony murder in perpetration of aggravated child neglect. So when the jury finds finds her not guilty of that charge, finds her guilty of reckless homicide and aggravated child neglect, it puts you in a different situation, because technically that's the definition of felony murder. So we're saying, okay, there was a reckless homicide and the underlying felony of the felony murder. And so I don't know how you separate those now at this point for sentence enhancement. And again, I think more so, not all cases are the same. This is a case where they're saying and said to the jury, we're not telling you she intended any of this to happen. And then, again, almost like with the age of the victim, if she didn't intend any of it to happen, then how do we hold her responsible anymore for particularly great injury that she didn't intend to happen than we did for age? This was a horrendous family tragedy, which has not been made any better for anybody because of this trial and its conclusion. It's still a tragedy, and it's as much a tragedy for Ms. Howington as it is for anybody else.
Unfortunately, Mr. Whalen, most of what this court deals with on a daily basis is tragedies.
I don't disagree, Judge, but we rarely see them at this level. I mean, in this circumstance. I don't know how pretrial release got to be a sentence of release to the community.
I'm not very concerned about that.
But I have to say, because the state has brought it out, if you look at the entire report, which is attached, I believe, to their memorandum, shows that she had 3 April, May, and June dirty drug screens, which for a regular user of marijuana would not necessarily be unaccounted. You would almost expect that to be true for 90 days. After that, she'd been clean every time they tested her. She did everything pretrial asked her to do, made every appointment, kept up with payments, kept up with payments for GPS. I would suggest she was very successful in that particular endeavor. So for those reasons, we don't believe that any of the enhancements should apply in this case.
What mitigating factors under the statute do you urge?
I would, number 3, that substantial grounds exist tending to excuse or justify a defendant's criminal conduct, though failing to establish a defense. And again, Ms. Howington, at this point, no one can deny that she was diagnosed and treated for PTSD based on the rape at the hands of a police officer in Sullivan County and the physical abuse and mental abuse and emotional abuse of Mr. Oliver, including 3 days before this event when he shows up and then wants to talk about how he's the victim of that. But she had to get a gun to say, get off my property. He wouldn't go away. He's upset because she got her boyfriend there. So there's that. Then we have that she comes home after taking the kids across town to their favorite park, comes home in the dark, is at the house, a shot rings out, which, as you recall, during voir dire, we talked to lots of potential jurors who had people with PTSD in their life, who said that shot going off would be a trigger. Then saying that it's your daughter has been killed and your son has pulled the trigger. All those things contribute to the mental state she is in when she is then taken to the hospital, not allowed to go with her daughter, but taken to the hospital, told her daughter is dead, and within an hour is in the interview room with Mr. Riddle. And when she tells them she's nervous because she was raped by a cop, he loses his mind and yells and screams at her and questions her humanity. At that point, that interview was over. She is fully triggered at this point, and by an officer who's sitting there talking to the woman whose child is dead and yelling and screaming at her over and over again. And the state then stands up again and says, well, you should consider as an enhancement factor uncharged conduct in that she tried to frame Antoine Oliver. The testimony is crystal clear. I asked them, who raised Antoine Oliver as a suspect first? They did. Then you asked her, do you believe he would do that? And she said, no, I guarantee you he didn't do it. And then they stayed on it until she says, I can't take it. You're right. I can't take it anymore. You're right. She did not try to frame Antoine Oliver. They did. And then you have the nerve to come in here and tell the jury different and then stand up at sentencing and say different. That is not true. It has never been true. She agreed with them after denying it and telling them she guaranteed him he did not do it. A woman who, in her mental condition, is in the interview room from about 11 p.m. until 4 a.m. with them. She did not get the 48 to 72 hours a police officer would have gotten to be able to get their thoughts together. She went from the hospital being told your daughter's dead to being interviewed. Further, we would say that number 7 applies, that she was motivated by a desire to provide necessity for her family or herself. And what she said from the beginning was that she puts that gun outside, and within minutes after all that is texting her friend to go pick up the gun, that Gavin killed Destiny. So she's telling that story from the beginning. She explains to them why, when she tells them that story, that she didn't tell them in the beginning say that to the police was because she didn't want Gavin to live with the fact that he had accidentally killed his sister. There's been no proof that that's not true, that that wasn't her motivation. And she was telling people she told Mr. Key from the beginning. And Mr. Key, again, has raised, I should have raised that on the enhancements, that he said he met her through somebody else who Miss Howington sold pills to. Your Honor may recall that the Friday before that trial, he testified he knew her, he was introduced to her to do odd jobs around the house. And he did odd jobs around the house. And he got some pills. And then he comes to trial, she says, how do you know him? Oh, as a drug dealer. That's not what he testified to at that hearing the Friday before the trial. That was not the first thought of Miss Howington. It was about that she paid him to do odd jobs around the house. But that part of the story that she was trying to protect Gavin was consistent if it wasn't the first statement she gave them, because she was still trying to protect Gavin at that point. She gives them the statement that an unknown black man fired a shot from the door. Clearly, she did not do that for racial reasons. Both of the fathers of both of her children, of those young children, are black men. She didn't have anything against black men. She's just trying to protect Gavin and keep them off of Gavin. Is that necessarily a rational concern? It might be if you got PTSD and you've just been through what she's been through. It would tend to make you irrational. The third mitigator we would submit is number 8, that she was suffering from a mental or physical condition that significantly reduced her culpability for the offense. And that, again, is just the same thing that I've argued before, is on the PTSD and what's happened that night in her home, and then being taken to the police department and abused by Detective Riddle in a way I've never seen happen before in any interview, or to that level. The last mitigator is that number 11. Although guilty of the crime, she committed the offense under such unusual circumstances that it's unlikely that a sustained intent to violate the law motivated the conduct. Unfortunately, when we look at what the medical examiner said, once that shot was fired, within 90 seconds at the most, that child, Destiny, was dead. The responding officer said, he tried to save her life, but by the time he got there, Destiny would have been dead. And he finally admitted that, yes, clinically, she was deceased. Clinically and in every other way by that moment. So it's a horrible thing, but for him, he did the best he could under the circumstances. So we would suggest, Judge, that there was, again, because of the way it's charged, even as a negligent act, it is hard to understand how you could negligently intend to violate the law in this matter, or that intent motivated the criminal conduct. It was this idea that she had a gun in the house and didn't know where it was. Had it not been for Mr. Oliver coming over and being upset that a boyfriend was there and taking the gun away from her throwing it on the ground, and he testified. Callie picked it up, put it back together. She testified. Callie said, "What do I do with this?" She said, "Put it away." When they asked her in the police department, "Where do you keep your gun?" she told them where she kept her gun. She wasn't thinking, she hadn't had that 48 to 72 hours, that she didn't know where Callie put the gun. It was just a horrible circumstance on that particular day that led that gun to be where Gavin could find it. So we would say that if the court finds that she has no prior felony convictions, and I think that's clear, and that if the court finds that there are no enhancement factors and finds that there is a mitigating factor, then we would ask the court to sentence her as a specially mitigated offender. It would reduce the sentence on that charge to 13.5, I think, and the lesser rate means nothing, but it's a constricted sentence under the statute that's still 85%. So that's what we would be asking the court to do.